Hi everyone, thanks for joining me today. So today we're having a chat about construction contracts and having a look at some of the key clauses in construction and related contracts and ways to best protect your business. So we'll get started. Just to introduce myself to start off with, I'm Rob. Rob Ney, co-head of legal here at LegalVision. By trade, I'm a general commercial lawyer, but my background's also in construction. So I'm really excited to be here with all of you today. Appreciate you taking the time on a lovely day, at least down here in the south. So let's get started. A couple of housekeeping notes before we get into the guts of the webinar today. So you'll receive the recording and also the slides that I'm presenting today. So don't feel like you have to take notes. Obviously, feel free to if you want to, but yeah, you'll get the recording and slides and you can obviously share that with other people in your business. And during the webinar, there is a Q&A box. So I've already got a couple of questions that have been submitted beforehand, so appreciate those. Just pop them in as we go through the webinar, and then in about the last 15 minutes, I'll open up the Q&A session and answer as many of those as possible. And then afterwards, what we'll do is we will shoot through a feedback form. So it takes a minute or two to fill out. Would really appreciate any feedback that you have on the webinar and the topics that I discussed today. So it'd be great. I'd be grateful if you can fill that out at the end. Last bit of housekeeping before I get started. As part of joining today's webinar, you get the benefit of a complimentary consultation with our team here at LegalVision. So essentially that is a 30-minute consultation with our team to discuss your business, that talk about the legal needs that you have, the legal needs potentially on the horizon as well, and to see if we're a good fit and talk about the ways that we can assist you here at LegalVision. So in order to claim that complimentary consultation, just leave your contact details in that survey that I was referring to, or you can just reach out on our website as well and just mention that you attended the webinar here today. Before I go through the agenda, I've just got a poll. So a little bit interactive here. Everyone who's online now, if you could just answer the poll here. So the question is, what concerns you most about your construction contracts? One is managing extensions of time, so EOT claims and delay costs. The second is liability for defects. Third is compliance with health and safety laws. Fourth is whether you have a liability cap. The fifth is all of the above. And if you're not sure, you're just here to learn, just select the final option there. I'll give you just a moment or two to lock in your answers. And then once you've all done that, what I'll do is I'll talk through the agenda and then get started with the webinar. Okay, perfect. Hopefully that's been enough time. Just see the results here. So interesting. The first one is extensions of time and delay costs with 67%. All of the above, that's good. Hopefully all of the topics will interest you. Defect rectification and liability caps. Wonderful. So obviously all of those topics are topics that I'm going to run through today. What I'm going to start with is looking at ways to assess risk on a construction project before stepping into time-related provisions, so extensions of time, liquidated damages, delay damages. Then talk about defects, defect rectification periods, performance security, before stepping into the liability provisions. I'll close with health and safety laws just briefly before, again, just opening it up for any questions that you have. Great. So I always think when we're talking about a construction project, and when I say a construction project and a construction contract, I'm going to try to keep this as broad as possible today. So I know some of our attendees are contractors, builders, trades, etc. Some other attendees are likely to be businesses employers or principals engaging a contractor to carry out a project. So I'll use that terminology of contractor or employer. But I also know that we've got project managers, engineers, other professionals who work in the construction industry. So as far as possible, I'll try to cover all bases and try to keep things as broad as possible. So before embarking on a construction project, I think a good starting point is to look at how we're going to assess risks going into that project. So one of the ways that you do that is to have a look at the key drivers that are important on a particular construction project. So both the employer and the contractor are going to have commercial drivers. So things that matter, things that are important to them in respect of a construction project. Once you've reached a landing on what these drivers are, then essentially that allows you to determine the risk appetite. So when I'm talking about risk appetite, I mean how much risk you're willing to take on in a project, how lenient you're going to be with the other side in contractual negotiations, whether particular clauses or risks can be accepted and lived with, and which of those risks that are really, really important to your business, again, depending on whether you're an employer or a contractor. You might have seen a graph like this. This is often a way that construction projects are broken down in terms of assessing risks. So we often say that in a construction project, there are time, cost, and quality factors that play into it. The reason why I've sort of got a triangle on the screen there is there's a bit of push and pull between all of these factors. So if, for example, you're an employer and what's really important to you on a project is you need to do a fit out of an office and you need your team to be in the office in 2 months' time, then what you might be thinking is you prioritize time because that's the key factor. And as a consequence, you don't really care so much about the aesthetics of the fit out. It's more about getting the team into the office so you can sacrifice quality to an extent and prioritize time. On the flip side, a project may be very cost sensitive. There's not a lot of budget. So again, you might sort of sacrifice quality a little bit, or you might be willing to engage a contractor who potentially has a longer lead time to start the project. So as I said, there's often a bit of push and pull between these factors. And I think that's why it's really important to try to work out commercially what is actually driving the project from your perspective. Or, for example, if you're a project manager, having a chat with the employer, your client, to work out what are these factors that are driving the project. And then obviously when you're looking at the contract and negotiating it, these drivers will inform how much risk you're willing to take in that construction contract. Great. So hopefully all that made sense. That's, I guess, a bit less legal, but talking a little bit about the commercials. And I think when we're talking about construction contracts, it's always really important. And the way that we approach things at LegalVision is to be very commercially pragmatic when drafting or reviewing or negotiating contracts to ensure that we're focusing on what actually matters on a case-by-case basis. When we're talking about extension of time claims and delays, what I'll do is I'll just briefly sort of recap what I'm talking about here and then talk through some of the things to think about when looking at clauses that cover EOTs and delay damages, liquidated damages. So understanding EOT clauses. Now, Often in construction contracts, they can be quite difficult to read. They can be quite lengthy. So what I find is really, really important is to make sure that even when you're not a lawyer, is to pay attention to the definitions, because often they are really critical in any commercial contract, but particularly a construction contract. You may have heard of terminology which is used in JCT contracts like relevant events, relevant matters. And generally, a relevant event is an event or circumstance that allows a contractor to make an extension of time claim. Now, why I say it's really important to look at the definition is ultimately that definition will determine the types of things that will give rise to an EOT and which things won't qualify for an extension of time. And from a contractor's perspective, if they don't qualify for an extension of time, essentially your potential exposure to liquidated damages is increased. Some of the things to think about with respect to extensions of time, I mean, some of the matters that may give rise to a claim, inclement weather, delays by the employer, delays by authorities in getting approvals for a project if they're the employer's obligation to obtain. Other things could be delays by third parties, again, third parties that are not engaged by a contractor. And you'll often see a lot of negotiation around these entitlements because it's obviously very important. As we all know, there's inevitably going to be delays on a construction project. So really, really important that we're clear on exactly what will allow the contractor to claim an extension of time and to be really clear in the contract. So that's sort of talking about what gives rise to an extension of time. Now, I think what's really important from a drafting perspective as well is to make the claim provisions and the approval provisions really clear cut. So who is actually going to be approving an extension of time claim? Are there timeframes in terms of when EOT claims are submitted, when they're approved? Again, just being really, really clear on what the process is. And then obviously, like when you've actually signed the contract, be familiar with the contract, particularly these provisions, to make sure that you're following it, regardless of which perspective you're coming at it from. On the right-hand side of the slide, I'll talk quickly about time bars. Now, time bars, if you're not familiar with what I'm talking about, generally they are in the employer's interest, and they essentially operate to say that if, for example, there is inclement weather on a particular week, the EOT provisions might say that a contractor needs to make a claim within 5 working days of becoming aware of the EOT entitlement, so the inclement weather. And if they don't notify within that time and make a claim within that time, then they are barred from bringing a claim at all. In other words, they have no remedy, they have no recourse. So obviously from an employer's perspective, that's really important because it's a good way of preventing extension of time claims being lumped up at the end of a project where a contractor waits until the end and then decides to make a claim for 100 days of delays. On the contractor's end, obviously, as far as possible, you want to try to remove any of those time bars. But sometimes, depending on who you're working with, that might not be possible commercially. Now, what I'll talk about now is sort of the remedies where there are delays from both perspectives. Now, sometimes there's different terminology depending on the type of contract, but what I'll focus on is liquidated damages, which are payable to the employer where the contractor is ultimately late in completing the works, and then delay damages, which are payable to the contractor in certain circumstances, often called for the relevant matters in the contract. Now, liquidated damages, essentially what you're doing with, well, both of these damages is you're agreeing with the other party on a fixed rate that is predetermined when you enter into the contract. And why that's important is ultimately, and it gives both parties certainty as to what the liability or what the compensation is going to be in the event of delays. Otherwise, I mean, you would be suing at common law and then you would be making a claim for general damages. And essentially, that's a more complicated process in terms of working out what those damages are. In construction, because of the prevalence of delays, it's really common and usual for there to be a fixed rate. From when we're talking about liquidated damages, from a contractor's perspective, ideally, they should be the employer's exclusive remedy. So what I mean there is that if you're a contractor and you're late in completing a project, so you don't finish by the date for completion or practical completion, then ideally you should only be hit with liquidated damages, and the employer shouldn't also be able to sue you for breach of contract. That's really, really important, and it's something that I see missed a lot of the time when people are advising contractors. The second point, again, kind of from a liability perspective, is there should really be a cap on the potential exposure. I would say market standard is probably 5 to 10% of the contract sum. So in other words, you can have liability for liquidated damages if you're late completing, but there's a ceiling on your exposure, which is essentially 5 or 10% of what you're making out of the contract. Well, not your profit, but what your payment entitlements are under the contract. On the flip side, when we're talking about delay damages, I guess from a principal's perspective, an employer's perspective, what you should be looking at is, what are the delays that you want to be compensating a contractor for? So, for example, if there's a variation entitlement, ideally there wouldn't be delay damages payable on top of that as well. But if, for example, as the employer, you delayed the project, because you breached the contract, then it may be fair to pay delay damages because the contractor might have had to step off site. Hopefully that all makes sense from a time perspective. If anyone has any questions about EOTs, I know that was sort of a key focus area for everyone online. Feel free to pop those in the Q&A box. I'll try to get to as many of them as possible towards the end. We'll now work through defects. So obviously, again, really common and important when we're looking at a construction contract. So again, my tips here would be to look at the definition. Often the definition of defect itself would be defined. Depending on which perspective you're coming at, you might want that to be as broad as possible from an employer's perspective. From a contractor's perspective, ideally you want that to be as limited as possible. In an ideal world, it's only where you've breached the contract. So have a look at the definition, make sure it's as tight or as loose as possible. And then also having a look at the defect rectification obligations. So ultimately, who's responsible for the defect? Is it a defect in design where a design consultant should be responsible? Or is it a defect in workmanship where the contractor should be responsible? Or in a design and construct model, for example, ideally the contractor is on the hook for all defects, whether they're design or design related or defects in the works themselves. And then also the other consideration, which is important and which will tie into the next slide, is when did the defect occur? Are we talking about a latent defect, which was sort of undiscovered until a later point, or was it patent? Was it obvious and it's clear there? Okay, so I've talked about defects in general. Now, some of the concepts in a construction contract to look at when it comes to defects is you'll typically have a defect rectification period. So that would, in a B2B context, that would usually be 6 to 12 months after completion or practical completion. again, and this is sort of recurring feedback, and a recurring tip here is look at the definition of practical completion as well, particularly from a contractor's perspective, to make sure that there's not things that are unnecessary lumped into the definition that makes it hard for you to get an actual certificate saying that you've completed the works. So usually, yeah, that defect rectification period will run from the work when the works are completed. And it's essentially a time when the employer can get the contractor back on site to fix issues with the works. Now, what there may be also, particularly for larger projects, whether that be a residential development or a commercial development, is there may also be manufacturer's warranties that run with any goods that are supplied. So if it's a fit out, that could be, fridges in an office kitchen. If it's like a large project, it could be large pieces of manufacturing plant that form part of the project. So those manufacturers' warranties are usually given by a manufacturer of the good or the product, and they are sort of separate from defect obligations in respect of the works. Usually, what happens is during the project as a whole, and then up to the expiry of the defect rectification period, there'll be an obligation, as I said, for the contractor to come back on site, fix defects. One of the things I think that's quite important, particularly for larger projects as well, is to have a look at whether there's a separate defect rectification period if a defect is fixed. So if, for example, there was an issue with, laying a slab, and the levels were not completely level, and the contractor has come back on site, they've properly fixed the levels, they've completed the work so that they're up to scratch, then is there sort of like a separate defect rectification period that applies only in respect of that particular defect? Or is it a case that there's just one defect rectification period across the board covering all defects regardless of when they are notified during that period? I'll quickly touch on performance security. Now, performance security, common in B2B arrangements, not so common in sort of B2C residential home development, contracts with a homeowner. But essentially, I mean, this is security in favor of the employer for the performance of the contractor's obligations. So it's essentially like a safety net that the employer has access to. So that could be in the form of retention monies, bank guarantees, insurance bonds, and it's generally about 5% of the contract sum. Half is released at practical completion, and then the other half is held by the employer until the end of the defect rectification period, with the main reason being it's a really important way of incentivizing the contractor to get back up on site because they may have started another project where your project as an employer becomes less important. Some of the other forms we see are a parent company guarantee on large projects, where there's any question about like the financial standing of the contractor, and potentially collateral warranties, which are given by subcontractors directly to the employer. For example, if the head contractor goes insolvent or absconds or anything like that, so that there's direct recourse for the employer against the subbies. Fabulous. I'm going to move on to liability provisions now. Now, some of you may have heard of a liability cap. Essentially, at its simplest, is a ceiling on potential exposure under a contract. Usually it benefits the contractor because they wear more risk in the contract, but it's not all that uncommon for the principal to potentially also have a liability cap as well. Now, it's completely unreasonable in any commercial contract, particularly a construction contract, for a contractor or a professional like an engineer, project manager, design consultant to have unlimited liability. So this is one of the critical clauses in a contract to make sure that at the end of the day, if you're providing the works or the services, you've got a cap on your liability. Now, what I would say is they are really complicated in terms of the drafting. And I would always say if there's one sort of clause in a contract that you get legal advice on, ideally the whole contract, but if there's one clause, it's looking at the liability cap. How they can be framed, they could be a percentage of the contract sum, they could be a fixed amount, they could also apply on sort of a per claim basis, or they could be aggregate. So, for example, you could have a cap that is 100% of the contract sum for each and every claim that an employer makes against a contractor under a contract, or it could be 100% of the contract sum, regardless of whether there's one claim or 20 claims. What's really important as well is often from an employer's perspective, you want to see carve-outs or exclusions from the liability cap. So certain circumstances where the liability cap won't apply. These are often really, really heavily negotiated because ultimately we're talking about things where the contractor is expected to have uncapped or unlimited liability. So that could be like gross negligence, potentially personal injury or death, noting that at law you can't exclude your liability for personal injury or death caused by negligence. It could be there could, for example, be things like breaches of confidentiality, breaches of privacy, for example, third-party IP infringement. Those are often things where it's relatively market standard to negotiate carve-outs from the liability cap. Another key liability provision, which I'll just touch upon quickly as well, again, really, really important, and one that is often sort of negotiated in line with a liability cap, is an exclusion of consequential loss. Now, what I mean by consequential losses are things that are indirect. So thinking like lost profit, lost revenue, contract, goodwill, reputational damage. So things that don't like naturally arise from a breach of the contract. For example, using the office fit out scenario again, if, for example, a contractor causes a leak in the building and then the office floods, in terms of direct damages, damages to the premises, damages to equipment that may have got wet, would usually be considered sort of direct losses. But if, for example, then the business wasn't allowed or wasn't able to get into the office, it delayed their launch by 5 weeks, they were a really large company. As a result, they lost revenue and profit. Those are the types of losses that we're trying to exclude. And the main reason for that is, generally speaking, consequential losses won't be covered by your insurance, or it may be the case that your insurance will only cover some of those losses or a portion of those losses. What I would say is it's really market standard for consequential loss to be excluded and for that to be a mutual exclusion for both parties to the contract. I know there's been a lot of content, so bear with me, and just a reminder about the Q&A box as well. I'll get to your question shortly, but before we conclude, and this is very, very high level, we could spend a whole webinar talking about laws and health and safety laws, but in the construction space, there's the CDM regulations in the UK, which essentially govern health and safety on construction projects. Now, a few key things just to note is there are statutory roles for a principal contractor and a principal designer. Now, a principal contractor essentially manages health and safety during the construction phase, whereas in the pre-construction phase, so the design development phase, that will be the principal designer's obligation. So typically a principal contractor will be the head contractor on a project. And note the role is required where there's more than one contractor on a project. But what's really important to note there is that includes where a head contractor has subcontractors involved on the project as well. So if you're a builder and you have electricians, plumbers on a project, then you will need to have a principal contractor. And it's the employer's obligation, except in a residential context, to make sure that those appointments are made, and they would usually be made in the contract themselves. Now, what's important as well is obviously these statutory rules apply, and you can't contract out of them. So you can't say that they don't apply in a contract. But what you'll often see in construction contracts is there'll then be contractual obligations that go above and beyond the obligations at law. So for example, you might have an indemnity in favor of the employer where the contractor causes a breach of the CDM regulations. As a contractor, as far as possible, you want to try to push back on those indemnities as far as possible. Great. So I know I've talked a lot. That was the key content of today's webinar. Now, what I've also prepared is a bit of a fact sheet, which is just a one-pager that you can see on the screen there. So feel free to just grab your phone now or when you've got the slides after the webinar and just scan the QR code and you can download that fact sheet, which talks about quite a few things that we've discussed today. Before we get to the Q&A also, we've got our next webinar, which is on employment contracts. So it's employment contracts essentials, ways to protect and grow your business. So join us on 8th of July, and you can just register through our website at the events page. Now, as I said, by joining the webinar, you've got access to a complimentary consultation. Now, one of the things we can talk you through specifically for your business is coming on board as a member at LegalVision. So essentially, we operate on a membership basis where we do all of your business as usual legal needs. So that includes drafting contracts, reviewing contracts, unlimited legal advice consultations, so 30-minute consultations with our legal team across all of our practice areas, trademark applications, 3 to 5 business day turnaround time, so really, really quick, and cost certainty as well. So you lock in a monthly price and you know how much you're paying for your legal spend each month. So claim your complimentary health check or consultation after the webinar, and hopefully I get to jump on some of those with you. Perfect. So Q&A session now. I will just open the Q&A box. Perfect. So just a last chance to pop in any questions that you've got. I've seen a couple come through, but would be really good to see some more now. So just pop open the Q&A box and I'll start answering those. Okay, the first one we had was with respect to sort of new housing developments and things like black mold and yeah. I think what the question is asking, well, I'm guessing, is sort of looking at ways that you can deal with potential risks in a construction project. Now, from a contractor's perspective, I guess what's really important there is to be really, really clear on the scope of work and being clear on what are the obligations as part of the works. You know, are there particular portions of the work that are excluded? And being really, really clear in the contract to make sure that at the end of the day, both parties know exactly what to expect. So that's sort of a scope point. Now, I think what's otherwise important is, again, to look at the extension of time entitlements. If, for example, there are site conditions like contamination or asbestos or anything like that, making sure that at the end of the day, the contract is really clear on whether that gives rise to a variation, and whether that gives rise to a contractor being able to claim time and cost. Okay, the second question we've got here is in respect of liability caps. So the question is it common for a contractor to not have a liability cap? Um, as I said before, no. Long story short, as far as possible, you want to make sure, particularly in a construction contract, that liability is capped, because at the end of the day, you're only getting so much out of a contract. So you want to make sure that there's a ceiling on what you can be exposed for. And there was a further follow-on question from that, which is it okay to tie a liability cap to the level of insurance? That is a really good question. And it's a question that I get all the time, day in, day out. And I often get that question asked by design consultants, so architects, engineers, and the like. Now, at LegalVision, we always try to steer against tying a liability cap to the level of your insurance. And the main reason for that is ultimately, and from an insurer's perspective, they are looking at ways to not cover a claim. That's the reality of it. They're going to be looking at exclusions to your policy to see whether something is covered or not. Now, if you've got a liability cap which is capped at the value of your insurance, then if you're not insured and you face a claim, then you're essentially up for uninsured losses. So what I would recommend, instead of capping it at the level of your insurance, is I would try to look at the contract sum, look at the value you're getting out, and ultimately coming up with a commercial call as to whether that's 100% of the contract sum, whether it's the greater or the lesser of 100% and a particular set number. And again, that's a commercial call, but really important to have a chat with your lawyer as well to make sure that what you're agreeing commercially is actually reflected in the contract. I've got another question here on design and construct versus construct only. So yeah, that's another good question. So these are essentially two procurement models in construction. Construct only is where an employer separately engages design consultants. They might have an architect, interior designer, engineers, and they will have typically consultancy agreements or services agreements in place with those design consultants. So if there is an issue with the design, the employer can bring a claim against those design consultants. Then separately, you'll have a construction contract, which will be construct only, where the builder is essentially responsible for building the works in accordance with those designs. But if there's an issue with the design, they don't wear that risk. On the D&C model, this is usually more sophisticated contractors where they may have an in-house design team. The contractor is essentially saying, we will take all of the risk of the design and the building of the works, regardless of whether we've actually prepared those designs ourselves. So you may have a situation, particularly on a large project, where, as I said, the employer has engaged design consultants, but then they enter into a design and construct contract with the head contractor. And all of those design contracts are essentially what we call novated, which means transferred over to the contractor. So essentially, the employer has one point of responsibility and they can bring a claim against the head contractor regardless of who was responsible ultimately for the issue, whether it's design or in the works themselves. Hopefully that clarifies that one. Still got a few minutes, and I appreciate pretty much everyone stayed online, so that's really great to see. I appreciate that. Last chance for anyone to submit a question now. Just pop open that box again. Last chance. Okay, perfect. Not saying any more. Hopefully, I've answered all of the questions that were submitted. If you did have any other questions that you think of now or after the webinar, what you can do as well is you can just pop it in the survey form, and either me or one of the our other team members can get back to you on that question. So just before we close, time to just book in your complimentary consultation. So I jump on a lot of these as well as other members of the construction team. So just fill in the survey at the end of the webinar today. Takes 30 seconds, nice and easy. Pop your details in there, and then one of our growth team members will reach out to you and book in that 30-minute session. Obviously, we can talk about things that we've discussed in the webinar today, but we can also be really focused on your business, talk about what you care about, what matters, what concerns you've got, your growth plans, how you want to accelerate that growth, and make sure that you've got good legal foundations in place to assist you with your journey. So yeah, really encourage you to join, to book in that consultation. Just fill out that survey form. That's all the time we've got today. I'm finished a little bit early, so I'll give you back a few minutes of your day. Thanks so much for joining me today. So I'm Rob. It's been a pleasure presenting this webinar to you today. Look forward to seeing all of you on those consultations. Just fill in that survey form. Thank you so much.